Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. And today, what I'm going to talk about is the affidavit that you have to file in advance of a hearing on objections that are filed in response to request for productions or request from the other side to produce certain documents, or an objection to interrogatories that are filed, which are basically questions that are asked of you by the opposing side. I've done separate videos on requests for production and interrogatories. So, if those have been filed in your case, and I'd suggest you go back and watch those videos first. But again, here I'm talking about specifically the affidavit that has to be filed to have a hearing on those objections. So I'm going to share my screen and show you the relevant statutes to start. So the first one is Practice Book Section 13-10. Has to do with responses to requests for production and also objections to the request for production. So if you scroll down to subsection I, it says that no objection to any request for production shall be placed on the short calendar list until an affidavit by counsel or self-represented parties is filed certifying that they have made good faith attempts to resolve the objection and that counsel and or self-represented parties have been unable to reach an agreement. The affidavit shall set forth 1, the date of the objection, 2, the name of the party who filed the objection and to whom the objection was addressed, 3, the date, time, and place of any conference held to resolve the differences, and 4, the names of all conference participants. If no conference has been held, the affidavit shall also set forth the reasons for the failure to hold such a conference. So basically, this section exists because the court doesn't want you just coming in front of the court and wasting the court's time if you haven't first had a discussion about the discovery request to see if you can resolve those amongst yourselves, basically. So that section is included for that reason. And then if you look at Practice Book Section 13-8, which has to do with objection to interrogatories, it essentially has the same language in subsection C that says you have to file this affidavit before you can have a hearing where a judge will resolve your discovery disputes. So I've put together a sample document so you know what you have to file with the court. So, it's an affidavit regarding, discovery or interrogatory objections. Obviously, just pick one of the two, or both, I suppose, if there's two separate objections. Then you're going to put that the undersigned, being duly sworn, is hereby states the following under the penalty of perjury. So all these things in bold are basically things that obviously the blanks you have to fill in, and what's in bold you have to choose one or the other or fill things in. So on so-and-so a date, the plaintiff or defendant, and then put the name of that person, filed either discovery request or interrogatory, and then include the pleading number. So you're putting, listing the underlying request that was filed. And then on so-and-so a date, the plaintiff or defendant, insert that person's name, filed an objection to the aforementioned discovery request or interrogatory at pleading number so-and-so. So insert that pleading number. And then the parties and their counsel include all the names. Again, that is a requirement of the statute. Held the conference on so-and-so date, time, and place in an attempt to resolve discovery. And then if you didn't have a conference, so presumably that would be like if the other side was non-responsive and refused to have a conference, that's going to be your most common reason. You're going to insert that explanation. So, say that you contacted opposing counsel 2 or 3 separate times and they didn't respond. So you really need these discovery objections heard by the court so that you can move on to the next phase of your case, basically. And then you're just putting, despite good faith attempts to do so, the parties have been unable to resolve the discovery objections. And then, whoever's signing this, either, if you're self-represented, you sign it, or if you're an attorney, the attorney signs it. And again, this is an affidavit, so it has to be sworn to under oath. And then the certification page, you put the contact info for all the parties so that once you file this affidavit, you send a copy to whoever's on the other side, basically whoever is involved in the case. So once you have that document filed, you can presume, you can ask the court to have a hearing on your discovery objections. By probably next step would be to file a case flow request. You can get a family case flow request off of the judicial website. If you search under, the family court forms on the judicial website and search for case flow request, you can ask for, first get this affidavit filed, and then you can ask for a hearing on your underlying objections. So those are the basics on the affidavit that you have to file in order to have a hearing on discovery in a family law case. As usual, if you have any questions, please feel free to contact our office. And if you are looking for representation in a family law case here in Connecticut, we would invite you to contact our office as well.